Welcome to today's LawWorks Legal Primer Series webinar, Advanced Estate and Care Planning. This webinar is organized by Pro Bono SG in collaboration with NTUC. My name is Liyen and I'll be your moderator. Before we begin, here are some housekeeping matters to take note of. Firstly, Q&A. Today we will be using Pigeonhole Live for our Q&A session. You can submit your questions at any point during the webinar and also vote for the questions by others that you would like to see answered. If you have a smartphone or tablet with you, just launch your internet browser, enter www.pigeonhole.at into the address bar, and then key in our event passcode, which is LawWorks04, as shown on the slide on your screen. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole Live on your device. If you are viewing this webinar on your desktop or laptop, you should receive an invitation to launch Pigeonhole Live. Next, useful information. A link will be shared in the chat function to access the handouts for today's webinar. The link will also be provided in the follow-up email sent to you tomorrow. And finally, please note that today's discussion is not intended to constitute professional legal advice. Please consult a lawyer if you require specific legal advice. With that, it is my pleasure to welcome our distinguished speakers for today's webinar, Mr. Patrick Tan and Mr. Patrick Tay. Our legal expert today is Mr. Patrick Tan, founder and CEO of Fortis Law Corporation. His areas of practice include trust and wealth management, legacy and succession planning, inheritance disagreements, and family law. Mr. Tan has assisted more than 30,000 international and local clients with their advanced care estate and legacy planning needs, such as making wills and LPA. Mr. Tan also speaks fluent English, Mandarin, Cantonese, and Hokkien. Joining Patrick Tan on the panel today is Mr. Patrick Tay. Mr. Tay is currently Assistant Secretary General of the National Trades Union Congress, otherwise known as NTUC, an elected member of Parliament of Pioneer SMC, and an elected member of NTUC Central Committee. He heads both the Legal Services and the Future Jobs, Skills and Training departments in NTUC. As both our speakers share the same name, I will be referring to them as Mr. Tan and Mr. Tay today. Mr. Tan and Mr. Tay, thank you both for joining us. Okay, so for this year's final session of the LawWorks Legal Primer Series, we will discuss a topic that every adult person ought to consider: advanced estate and care planning. Now, if you signed up for this webinar, you have already taken that first step towards making some perhaps difficult, but definitely necessary decisions for your life and for the benefit of your loved ones. Mr. Tan, perhaps you could start the ball rolling. Why is it important to think about advanced care planning and estate planning?
Sure, Liyen. Actually, as advanced care planning is all about planning for your future health care, right? Because statistics have shown that many Singaporeans, many of us will fall sick, right? So it is important to talk to our loved ones to let them know how we want to be looked after when we are very ill. Whereas estate planning is all about planning how you want your assets to be administered after you're no longer around.
So, I mean, maybe Mr. Tay, you can chip in, right? What I've spoken often to relatives, family members about doing a will, doing an LPA. Some of the answers I get, okay, one common one is, mine very easy. I only have nothing much, one HDB flat, so no need to do. I mean, how should we respond to people who think like that?
Yeah, I think that's a common refrain from the residents there, and of course the unionists and the union members as well. Many of them, when they share or when they talk about this, they take it quite lightly. But many didn't realize that actually the challenge or the difficulties and the issues start cropping up, and either you are on your deathbed or even post after you've left this world. I think very, very important, because I also personally have seen many disputes among family members, relatives, because of instructions not given properly, not given ahead of time, and of course not given clearly. So actually, with proper planning, both in terms of advanced care, estate, as well as even for the lasting power of attorney, and these are all various instruments so that they'll give you, as a person, autonomy to decide what you want if the eventuality happens, and to give clear, precise instructions so that the people that come after you don't end up second guessing and going to disputes and quarrels to kind of like guess what you actually wanted or what was your will or your intent. So I think it's very clear. I mean, I've seen quite a number of residents and friends as well who face difficulties in this space. So essentially, today's session and then touching on these few areas are basically to make your life and the people that come after you, especially close family members, a much easier and a peaceful one.
I definitely agree with that. I think it's particularly difficult also for loved ones to make decisions regarding ourselves, either when it will already be a tough time for them. They're either grieving or at a loss if we are very ill. So I never thought of it that way until I was preparing for this talk, really, that when we think about advanced estate and care planning, it's for the benefit of our loved ones. Yep. And we do it for them. So just, don't just think that my estate is very simple, it's very easy, nothing needs to be done. I mean, it is really an act of love when you plan for your advanced care as well as your estate beforehand. Would it be fair to say?
Yes, totally agree. Like you correctly mentioned, advanced care and estate planning, right? It's not just for ourselves, it's for our loved ones, especially for estate planning, right? By the time your will come into effect, you're no longer around. So it is really about planning for your loved ones. It's an act of love and an act of gift. And advanced care, so on one level, it seems like it is about how we want to be looked after, but it is also about your loved ones to prevent quarrels, misunderstanding. Because the last thing we really want is for them to fight and quarrel over how to look after you. That will be very tragic, right? So we have to let them know, because we cannot assume that our loved ones know how to look after us. We are not talking about minor illnesses, cough, flu, fever. We're talking about serious illnesses, right? So, and we cannot expect our loved ones to know how to look after, because it's not easy. So we really have to let them know, right? Which hospital you want to go to, which doctor you want to see, whether you want surgery or not surgery. You have to let them know, because all of them, all your loved ones love you in their own ways, right? They may differ in how to look after you. So it is also about preventing quarrels, misunderstanding among them. So it is important.
So with that in mind, let us maybe go through an overview of the topics that we will be discussing today. Mr. Tan, would you like to take us through a brief overview of all the topics that we intend to discover today?
Sure. So for estate planning, right, we are going to talk about the importance of having a will and what happens if you do not have a will. Now, Singapore is very straightforward as far as the law is concerned for inheritance. So it is either we pass away with or without a will, right? If we pass away with a will, then of course our assets will be administered in accordance with the wishes stated in the will. Now, if we pass away without a will, we have a law called the Intestate Succession Act that will actually decide and determine how our estate will be administered. Of course, this is for non-Muslim friends. For our Muslim audience, right, basically your estate will be administered in accordance with your religion, Sharia law. All right, so it is important. So we're going to talk about what constitutes a will, a valid will, what happens if you pass away without a will, and what assets go into your will, and what assets will be excluded from your will. We're going to talk about all these things. Then for advanced care planning, we're going to talk about advanced care planning workbook. What kind of document is this? Right? What does it do for us? And this very important legal document called lasting power of attorney. All right, and what can this document do for us? And what kind of powers does a donee have under the lasting power of attorney? And also the latest initiatives by the Office of Public Guardian. They have actually digitalized this process of registering the lasting power of attorney. So we're also going to talk about that. And what advanced medical directive is, basically, it is also an important legal document that basically tells your loved ones and healthcare professionals that you do not want life-sustaining treatment to prolong your life in the event that you are terminally ill, unconscious when death is imminent. So we're going to talk about all these important documents later on.
That's excellent. Actually, quite a number of these are fairly new to me. So I'm really quite excited to move on so that we can cover all of these topics. So let's begin with the first one, which is the most common, I think, and all of us would at least have heard of it or thought of it if we don't already have one. So Mr. Tan, perhaps tell us what are the requirements for a legally valid will?
Actually, you'll be surprised. Under Singapore law, right, what the requirements that constitute a valid will, it is not onerous, not complicated, right? So first thing first, of course, your will has to be in writing, right? It cannot be verbalized. So don't believe what you watch on TV. Before you pass away, you verbalize some instructions. Those are not considered a valid will. So under Singapore law, your will has to be in writing, right? It has to be in English, preferably. And most importantly, you need 2 independent witnesses to witness the signing of the will. All right, you cannot have 1, you must have at least 2. And for our Muslims, right, you can also do a will. It is called a wasiat, right? And in order for your wasiat to be valid, you need 4 independent female Muslim witnesses, or 2 male Muslim witnesses. So these are the basic but yet important requirements under Singapore law.
Wow, okay. Does that mean that if I meet those requirements, I can make my own will?
Preferably not, because making a will may appear simple, but it is not simple. There are many things that we need to take into consideration, like what assets can go under the will, what assets cannot be given under the will, and also the importance of appointing this person called an executor and trustee in your will, or a guardian to look after your minor children. So there are many different aspects that go into making a will. So do not attempt to write your own will unless you know how to do so.
Mr. Tay, I believe you have recently experienced making a will. How do you, did you try to do your own?
No. I did not try to do my own. I did it not just before COVID, and had the will probably done through a lawyer. My recommendation is to do it through a lawyer, simply because you want to make sure that things are right and in order. As Patrick earlier shared, there's a possibility that you comply with some of these requirements for a valid will. It may be a valid will, but my recommendation is go through a lawyer so that you can not just have the will to ensure that it's properly documented, but also submitted to the Wills Registry, which is now available, the SAL, Singapore Academy of Law. And at the same time, also to make sure things are in compliance. And of course, in some instances, lawyers actually do offer several kind of services. They can either lock it up for you somewhere, and of course at a fee. At the same time, also to make sure things are correct in order. Why do I say that? Because when we start writing a will, we didn't realize that there are a few other things that make up the will which are important. For example, like executor, who to be an executor. So, I mean, you write a simple will and appoint anyone an executor, please think through this thing through, because there may be other ramifications downstream if you choose the wrong executor. So it's very important. So things like that, the lawyer will advise and discuss with you who is the best person to do it, and to help with the arrangements. Because it's not so straightforward. Because if anything happens, sometimes you're not around, or your entire list of beneficiaries or other beneficiaries are not around, and those are the complications that arise. You don't choose the right executor, for example. At the same time, also assets, and increasingly, because nowadays we not just have tangible assets, we have digital assets as well. So I think things get a bit more complicated. So when things get too complicated, it's good to have it properly documented, listed out in a manner which is clear and not ambiguous. I think these are important points to take note of. In my experience, having, of course, not just the fact that I practice the law, but also as in executing and doing up the will, these are important considerations for each and every one of us.
Well, I better go and see a lawyer soon. Okay. What happens if one dies without a will? That's something that I would like to address, because I certainly have had many people, especially older, much older relatives, say that it's okay, mine, I don't need will because I just have, like, whatever, these few things. But I have witnessed personally, to my surprise, that when they do pass on, actually the children still face issues. Basically, family members who are left behind are completely at a loss. They don't know what to do. So maybe we can quickly talk about what happens if a person dies intestate. Patrick, Mr. Tan.
Okay, as I said earlier, if you pass away without a will and you are a non-Muslim, then basically our Intestate Succession Act, which is a law in Singapore, will dictate how your hard-earned money will be administered. Now, let the law decide for you. You might as well decide yourself, right? Because we are talking about your own money. Why let people decide for you? Doesn't make sense. So logically, you need to have your own will to tell your loved ones how all this hard-earned money and asset, how would it be administered? Because if you don't, later we'll explore more about this law. The law has a formula. So basically, your asset will be given in accordance to this formula. And that is the key, the single most important reason for having a will is that you do not want to let the law decide for you how your hard-earned money will be administered, right? And number two, some may say that, okay, but I agree with the law, the distribution, the formula, I quite agree. Let's say that if I pass away without a will, half go to my spouse, the other half go to my children. That's exactly what I wanted. So why bother to make a will, right? So let me share with you why it is important. Because like what Liyen said earlier, administratively, it is much easier to have a will. Because when a person passes away, you need a court order. If you have a will, right, the court order is called grant of probate. If you don't have a will, the court order is called grant of letter of administration. Now, I can share this with you because I do this day in, day out, right? So if you have a will, we will have a grant of probate. And the process, the time taken, the cost involved for getting a grant of probate is much simpler, faster, cheaper, as compared to the court order. If you don't have if you pass away the grant of letter administration, the process involved is actually more complicated. And also, if you pass away without a will, who is going to be your executor? Like what Mr. Tay said earlier, it could be a very tricky issue. Because if you pass away without a will, it's going to help you distribute. No one is going to help you transfer or sell your HDB or go to the bank and take out the money, right? So you need to have somebody. Now, who is this somebody? Now, this is a tricky one because personally, professionally, I fought in court quite a few cases involving where a person died without a will. So the family actually came together and they had this issue of who is going to be the administrator, who is going to be the person in charge of administering the asset. So the spouse would say, I want to be the administrator. Then the children disagree. The children say, no, I wanted to be right there. So basically, they spend a lot of time arguing who to be the administrator. In fact, recently, I think in the papers, there was this guy who got charged and convicted and sent to prison for misappropriating the estate. So this brother was actually the administrator of, I think, his late brother's estate. The late brother died without a will. So the family agreed for him to be the administrator, but for some, he took the money, he did not distribute it. So you see that there are issues like this. But if you have a will, right, the appointment of executor is very clear. When you open up the will, I appoint so and so to be the executor. So there is no dispute. But if you don't have a will, you're leaving it to chance, You hope that your wife or your husband or your son and daughter will come and administer. I've done cases where nobody bothered. Because they know that even if they step up, they're not going to get a bigger share. So why bother? Right? Not that they're going to get more, So they act blur. And I've also done another camp where everybody wanted to volunteer because they just do not trust one another to do it. So in both of these cases, it will result in delay, right, quarrels and all these things. So there's so many reasons why you need to have a will. To me, basically, there's no reason unless you have zero, nothing to your name. Then maybe. But otherwise, it's a given.
Very interesting. Actually, now that you talked about that, doesn't it mean that who you choose to be your executor also quite important, like Mr. Tay had earlier said, right? So any advice, if I'm doing my will now, who should I pick? Like some kind of a guideline? The person who I think loves me most. If I pick one child and not the other, is there?
So like what Mr. Tay said earlier, right? Appointing executor is important, very important. In fact, to me, that is the second most important reason for having a will. The first is basically you tell your loved ones to get your asset. The second is basically appointment of executor. Why? Because this is a very important person. He or she is going to help you administer your estate. So needless to say, this is a person you trust the most who can do the job. All right. But having said that, right, if you have two children and both of you will love the same, how are you going to appoint? So the question is, do you appoint both of them as the co-executors? But appointing both also got its own issues, right? That means both have to go to the bank together, both have to sell, can be very troublesome, very legit. Then you appoint the son, not the daughter, also a bit imbalanced. You also feel that, okay, maybe I'm not being fair to my daughter. So how? All right, so that there is no easy solution. You need to think through this issue very carefully.
So interestingly, that both of you brought at this point an executor. And having heard some of the issues on the ground, the residents, so I can't emphasize more how important it is, because I mean there are few considerations. Well, the good thing is these days they are professional executors, which you can engage with a fee, who can assist with being an executor with a will in case the eventuality happens. I mean that's one way out. You don't really have a fee at that sort of thing. But the other thing also you need to consider as well. Why we don't appoint sometimes family members like your spouse, your children. I mean, that should lah. I mean, you never know. For example, you go on a family holiday, everybody goes off, and so who handles the estate? So that's why most of the time the advice would be to get someone that's outside the family, possibly, and someone whom you're close enough, and whom you can trust, and who can be able to do it in the manner which which the family members and whoever comes after you will be able to look up and be comfortable with.
Okay, moving on. Maybe just very quickly, before we talk about assets that need to be included in a will, we do have quite a bit to cover. After the will is done, does it matter for me as a settlor, what am I going to do with my will now? Assuming all finished, I've got the witnesses, it's properly done, it's a valid will. Do I tell my children? Do I keep it in my drawer? What should I do with it?
There is no legal requirement to actually inform anyone, right? No legal requirement. But of course, practically speaking, somebody should know. Otherwise, as good as not having a will, right? You keep it so confidentially, nobody knows that you have a will, then what's the point? So who do you need to let know? I mean, like basically your executor. Your executor has to know that you have a will and where you keep it, right? Otherwise, because on the ground, I've seen many of these cases. Say, oh, my daddy has a will, but I cannot find it. Then I say, then how, how do we go forward? So you need to let somebody know. And also, Singapore Academy of Law, they have a will registry. So it is optional, but you should consider registering your will with them, so that in case your family members they need to find out, you can actually approach the will registry and find out whether the daddy mom, right? Things like that. In case you do not want to let anyone know, then the very least you should do is to actually have your will registered at the will registry, and also keep it safe. And do not keep it in, if let's say you want to keep it in a safe deposit box with a bank, do not keep it in the box that is in your sole name. Because if you do, and when you pass away, how do you expect your next of kin to go to the bank and say, can I open my daddy's safe deposit box? They're not going to let you open the box. So it's like in football parlance, right? World Cup, you score own goal. Basically, you mostly score own goal. So if you want to actually put in a safe box, you have to put it in a joint account, a safe box, so that your safe box joint account holder can actually access. But having said that, that is if you do not inform the bank that the one of the joint account holders has passed away. Because in my experience, if you let them know, they will close the account and you will not be able to have access to the will kept inside.
Okay.
So you need to be very careful.
Yeah, that's something that I think some of us definitely would not have thought about. Okay, let's talk about the assets that need to go into a will. Yeah, Mr. Tan, maybe you can run us through that. So now we're covering the main body of the will.
So your Singapore will can cover what we call immovable property, basically your real estate, like condo, HDB, flat, landed properties in Singapore. But if you have properties overseas, right, then you should do a separate will overseas, right? So that this overseas will or foreign will can cover your foreign asset. So your Singapore can cover your Singapore properties and also what we call movable assets like your cash, your shares, your businesses, your jewelries, your personal effects. So it can cover many things now, but there are a few things that your will cannot include.
Oh, but before we move on to that, right? I'm curious. You mean if I say maybe shared with a friend and bought a piece of property, maybe a condo overseas, and I put that in my Singapore will, what is the problem that may arise if that's an overseas property?
Because not every country in the world will recognize our will. They have their own definition, what is a valid will in their own country. So my concern is that what is valid, what's considered a valid will in Singapore may not be considered a valid will overseas. So that is a problem that is surfaced in the. So for prudence sake, especially when we have assets in what we call a civil law country, because Singapore is a common law country. So if you have assets in a civil law country like Thailand, like Vietnam, Laos, China, Korea, Japan, Taiwan, even, right? They are civil law countries. So you have assets there, then you have to do a separate will.
I see. Okay, that's some interesting additional information. Well, okay, let's also then talk about assets that cannot be included in the will, because I think that would be very useful for, that would basically, all of us have these assets. So let's talk about them.
Yeah, so basically you can only give your own things in your will. Of course, you cannot give other people's things, right, in your will. That makes a lot of sense, but it sounds almost like, okay, so basically you cannot give other people's things, okay? And there's a reason for me saying this, because I'm coming to the point of joint ownership property. So you may think that, well, joint ownership, joint bank account is mine, it's my money, or joint HDB flat is my flat. So can I include that, even though it is joint? This is a bit tricky because we have this law called the right of survivorship, right? Right of survivorship. Now, as the name suggests, right? Whoever survives becomes the sole owner of this joint asset. Put it another way, whoever dies first will lose all interest in this joint asset. So, to put it bluntly, if you want this joint asset to come under your will, you have to outlive the joint owner. If you do not outlive, then this joint asset cannot come, because the moment you die, you already lose the interest. You no longer own this asset. Since you no longer own this asset cannot come under your estate and your will. And now, what joint assets are we talking about? Joint bank account, like many people join here, join, right? Like to join with your wife, join with your son, join with your daughter, but you have to understand the right of survivorship. In fact, I am fighting a few cases in court now involving joint account monies. It is a complex area of law. So basically, your will can include monies in your pocket, monies in your own account, but may not include monies in joint account because of the right of survivorship. And this right of survivorship also applies to properties. So for instance, if your HDB flat is jointly owned, what we call joint tenancy. Now later after this talk, go and look at your title deed. These words will be there. If you see joint tenancy, right of survivorship will apply. So if you want your HDB flat to come under your will, don't die first. You have to outlive your joint tenant, right? But if your joint ownership is tenants in common, TIC, tenants in common, meaning there is a share. So tenants in common in equal share means 50-50. Then in that case, right of survivorship will not come. Even if you were to pass away first, your share can be included in your will. So after the talk, go and check, is it joint tenancy or tenancy in common? So that is for joint ownership property. Many people don't know this, but now we know, right? That's CPF money. So when a person dies, all your CPF accounts will be closed automatically. Your ordinary MediSave special account. Now your CPF balances will be remitted to the public trustee office. What they want to see is whether you have done a CPF nomination. If you have, then your CPF balances will be remitted to your nominee's bank account or CPF account. Now, if you have not done any CPF nomination, then basically your CPF balances will be administered in accordance with the Intestate Succession Act, the same law that I talked about earlier. So to put it simply, your CPF balances cannot come under the follow CPF nomination. So please do it. You can do it online on CPF website, or you can visit CPF branch office to have it done. And thirdly, insurance with nomination. So when you buy insurance, you can nominate a beneficiary or you can don't nominate one. So if you have nominated a beneficiary, then the insurance payout will go to the nominee. But if you have not nominated a beneficiary, then your insurance payout can come under your will. So very straightforward. You nominate, go to the nominee. Don't nominate, comes under your will. So basically, these are the few key assets that cannot come under the will.
Okay.
But I can't emphasize more. You know, as you do up the will and list down the assets, I think it sounds a bit morbid, but it's very, very important to list down all in a very extensive manner, every asset you own. And make that list available either through Google Cloud is one way, or some sharing it amongst family members. And of course, now particularly with a very digitalized, very virtual world, we have all sorts of assets. These days you have crypto, these days you have this account here, these days we have shares, these days you have treasury bills, Singapore savings bond, name it. You have all sorts of instruments. So as a good measure, to always list down all these assets, because frankly, your family members or people that come after you don't know what they don't know. So it's very, very important, including like what Stan shared earlier about listing whether they are joint tenancy or tenancy in common, or in what form and shape it is, and including in some cases, because I know some of our Singaporeans actually buy properties outside of Singapore, to list some of these down. So the more extensive the list you have, easier for subsequently then for your executor as well as the members or the beneficiaries of the will to then slowly go through each and every item and try to search for the documentation. Well, these days most of the things are digitalized, including title deeds. But I think good measure to have an extensive and contemporaneous list. So good to visit your list of assets every 3 to 6 months. Make sure that it's contemporaneous and up to date.
I think Mr. Tay raised a very good point, because your will may be simple, maybe general, right? But your executor may not know what you have. So you need to keep an inventory to make sure that your executor know exactly what you have. So imagine if your will say that I give this person 50%, 30%, 20%. It's meaningless if they do not know what you have. So you need to ensure that although your will is general, you need to have an inventory, right? Listing down what you have. So next time, if your asset changes, right, you can update your inventory without disturbing the will, right? In case you're thinking, also every time I change my will, I have to kind of change my asset to change my will to pay more, right? So you don't have to, as long as you don't change the percentage, right, in the will, right, you can update your inventory without disturbing the will.
Yeah, and I have actually personal experience with that. So thank you very much for saying that. I was once an executor for a will, or rather for a loved one who passed on. And it was quite stressful because we were, her relatives suggested that she had more bank accounts that we knew of. So we really had to get the lawyer to write to banks that we thought maybe she has an account, and the whole process was long, it was tedious, quite stressful.
Yes.
So yeah, as an executor myself, I strongly suggest that those of us who do a will, we should really regularly update. Sometimes we ourselves forget what we have.
Sometimes it's exacerbated. I have residents come to me and then same situation. So they didn't know which bank did their family member who passed on put their money in. Of course, you have local banks, but these days you have digital banks as well. And you have digital wallets as well. So that exacerbates the whole problem, and it may be small amounts, but it's the whole rigmarole of having to, the energies and the time and the stress to go through all this.
Yes.
And now we have foreign offshore banks as well. So it does not help. So all this will add to the challenge. So as as an advice to everyone, good to have a clear list, a inventory list.
Yes. Yeah, thanks for mentioning that. Okay, before we move on from wills to LPA, first of all, as a reminder to participants, if you have questions, please use Pigeonhole and raise your questions with us. So now I just want to ask a few questions that have come in from participants regarding wills, right? Can an executor also be a beneficiary of the estate? Mr. Tan?
In fact, very common. executor can be a beneficiary, but a beneficiary cannot be a witness to your will. So executor can be a beneficiary, but beneficiary cannot be a witness. In fact, it is very common for people to appoint their beneficiary as the executor because their interests are aligned, correct or not? So they should execute well, solid one, because they have also stand to benefit, correct? It makes sense. So if you have trouble thinking who to appoint, right, consider appointing the biggest beneficiary. Confirm do a good job. That is fine. That's my experience. Whenever a client asks me, who Patrick, can I appoint? I say, who do you want to give like 90%? For example, you want to give everything to me, I volunteer to execute your will for you. Correct? Because it makes a lot of sense.
Yes.
But like what Mr. Tay said earlier, if let's say this person is a close family member of yours, then you have to be extra careful, especially if you travel together and all this, right? What if both of you go together? Then you need to have a backup law. So in your will, you can appoint a backup executor in case the first executor go together with you while on holiday. Then there is a backup who is outside your, this close circle of relation to execute the will.
Perfect. That answers also another participant's question, which was who is a suitable executor, right? As well as the other one. Okay. How long does it take to write a valid will and changing it along the way? I mean, is that a long drawn process? You earlier mentioned that if all you're doing is changing the inventory, that's no problem. Maybe I think this participant wants to know, say if I approach a lawyer, how long does it take for a valid will to be completed?
Other lawyers, I cannot say. My standard is 30 minutes. But it is not that it is easy because I've done many. I'm very experienced, right? So basically, for my standard is 30 minutes. I can write my own will. It took me 10 minutes. But for your will, right, if it's not complicated, right, I take 30 to 45 minutes. I should be able to draft the will for you. But this differs. It varies from lawyer to lawyer.
Okay, there are a few other questions regarding wills, but we can save that to the end of the talk. I'd like to move on now to talk about the advanced care planning workbook. Now, earlier in your overview, Mr. Tan, you mentioned that advanced care planning covers sort of three separate parts. There's the advanced care planning workbook, then there is the LPA, which we will talk about quite extensively in a bit. And then finally, there's the advanced medical directive. Yeah. So let's start with the advanced care planning workbook. That's actually quite new to me. Can you tell me what that is?
Actually, all these are important documents. There are tools under this advanced care planning framework. Advanced care planning is all about actually having conversations with your loved ones, to basically let them know clearly what your thoughts are, what your healthcare preferences are, what your values are when you are very sick. Right. As I said earlier, statistics have shown that more than 70% of us will become very sick. And we cannot assume that our loved ones know how to take care of us and what our healthcare preferences, what our values are. We really need to let them know. We need to tell them. Right. Because by that time, if you become very sick, you may not be in a position to let them know already. Then they will all panic. They will be under a lot of stress, don't know how to look after you and all these things. So it is all about talking to them, having conversations with them, make sure they know very clearly. And so these tools, they talk about advanced care planning workbook, lasting power of attorney, and AMD. These are all important tools to basically achieve the objective of what I have said earlier. Basically is to let your loved ones know. Right. So as far as advanced care planning workbook is concerned, right, it's been around for a while. It is not a legal document, but it is an important document. Now, in this workbook, what we call the advanced care planning facilitator. So there's this group of professionals. They are trained and they are qualified by the Ministry of Health, Agency of Integrated Care. So they are trained to actually help you and your loved one. This person is called the healthcare spokesperson, as a nominated spokesperson. Basically, they will take both of you through this exercise to fill up this workbook. And inside this workbook, it contains a series of important questions related to your advanced care planning. Like, for example, do you want surgery or not surgery? This kind of thing, pain threshold. Which hospital do you want to go? So they ask a lot of this intimate healthcare information. And after completing this this workbook, right, which typically takes like maybe an hour or two, they will help you complete a form. There is a form, not the workbook, but a form. And after that, right, this form, which contains your advanced care planning instructions, will be registered. There is actually this national database called the National Healthcare Record. So it will be registered there. So when you become very sick, the healthcare professionals like your doctor and nurses, they can actually extract this form and then take into consideration your healthcare preferences and formulate a care plan. So this care plan will basically include your preferences so that your family members, the healthcare professional, know how to look after you. Right. So it is a very important, because otherwise, right, nobody would know what your healthcare preferences, what your values are, and so on and so forth.
I think the good news is not to worry. I think we have managed to push out the resources for this. Like what Patrick mentioned earlier about the Agency for Integrated Care, which is actually looks after this space. If you go to the website, the links are provided for you on the
in our chat function.
Chat function. So make full use of that. It's actually I've just gone through the entire web pages and resources. Very, very extremely useful. It's almost like a step-to-step guide. So not to worry. If you are still want to find out more about this and want to know the steps and what is this ACP group and the process and who are the healthcare professionals that can assist you, it's all available in their website. It's quite comprehensive, so very useful, very instructive. So if you have time later on after tonight's session, you can actually access it in a very readable and easy to refer format.
So is it, who should do the advanced care planning then, Mr. Tan? Because or even Mr. Tay, is it something that a healthy person should consider doing, or should I kind of wait till I, unfortunately, but have been diagnosed with something? I'm not sure who it covers. Is it something that everyone should do, like when we're talking about a will, or does it apply to someone who is ill?
I think everyone should do, as long as you are above 21 years old. Never wait until it is too late, because by the time you will be very sick, you may not have the right frame of mind, you may not have the mental capacity to plan ahead. When things happen very quickly sometimes, right? So you need to plan ahead. Similarly for a will, right? I always advise my clients to not leave it to the last minute. I lost my best friend at the age of 39. He died alone in his apartment at the age of 39 due to a heart attack. And 2 days before his death, 10 years ago, this year is his 10-year anniversary, death anniversary. And we were having lunch. It was well. And 2 days later, I lost my best friend. So you can never time this, right? I always say that you do it as soon as you can. Right? I did my will when I was 28 years old. Now I've changed my will 4 times. So you don't have to worry that if you make a will today, everything is stuck, you cannot change. Can be changed, can be updated. Same for this advanced care planning. Whatever documents we talk about it tonight, it can be changed, can be updated. So you don't have to worry that you are stuck. So please get all these documents done as soon as possible.
Yeah. I just want to add on to what Mr. Tan mentioned about, don't wait, because we have seen instances where sometimes even my residents are going to dementia, and as well as some in Parkinson's disease, and so in that sense, they will not be of sound mind to execute and to give certain instructions. So always good do it as early as possible, and where practicable. Of course, I know also of people I come across who, when they detect that they have cancer, for example, maybe they are stage 1. So they start doing some of these procedures, giving some of these instructions. Sounds morbid, but I mean, at least you leave instructions that are clear. Of course, some like Stan's friend, they didn't have the luxury of time. So I think our general advice is to do it where possible and where most expedient.
Okay, that was very helpful. Thank you. Let's move on quickly to the Lasting Power of Attorney and the Mental Capacity Act. There was a question I had about choosing the healthcare spokesperson, but I wonder if it would be similar to choosing a donee in the LPA. So let me before I bring up that question again later, just for the benefit of those of you who thought of that, let's first deal with the lasting power of attorney, which is the second part of advanced care planning. What is this lasting power of attorney and when does it take effect, Mr. Tan?
LPA is a legal document that allows you to appoint this person called a donee to make certain important decisions on your behalf when you lose mental capacity and the ability to manage your own affairs due to whatever medical conditions, right, that cause you to lose mental capacity. So if you have done an LPA, the moment you lose mental capacity and the ability to manage your own affairs, the donee can basically help you make certain important decisions. Now, just because you're married, you have children, your parents are still alive, it doesn't give them the legal authority to make certain decisions on your behalf. You need to legally authorize them. And the document that gives you the power is LPA, right, which came into Singapore around 2010 under the Mental Capacity Act. So before 2010, right, we didn't have lasting power attorney. So when I was in practice then, right, I saw many problems on the ground. When a person loses mental capacity, right, many things were stuck. And the family had to go to a lawyer like myself to make an application to the court. At that time, it's called committee of person application. Nowadays, it's called deputation. And it is an expensive exercise, at least a couple of $1,000, and it take a few months, right? So it created quite a lot of problems for many people. So I think the government saw a need, right, to allow people, to create efficient way for people to basically help the parents or whoever who lost mental capacity to make decisions. So that's the reason why they introduced LPA. So if you had registered a lasting power of attorney, the moment you lose mental capacity, there is no need for your loved ones to apply for any court order anymore. Straight away, the donee can step forward and make these important decisions on your behalf without the need for any court order.
In fact, that reminds me of what happened 2 days ago at my Meet the People session. Two family members, the dad and the son, came and see me and wanted to take out some monies from the bank, and not a big sum of money, just a small sum of money, but they faced challenges because the mother or the wife, who was the one being cared for, went to quite serious stage of dementia. And therefore, there was no LPA or lasting power attorney executed, and therefore they came to see me. Two interesting takeaways for me. Firstly, don't wait till you get demented or you go into a state that you can't make decisions or of sound mind, and therefore cannot execute a proper LPA. Then it's too late. That's one. And the good news is, the so-called filing fee or registration fee is waived till 31st March next year. They've extended a few times, so hopefully they'll extend again. It's under the Ministry of Social and Family Development, under the Office of Public Guardian. But the other thing that came up also is, that's what Satan mentioned. If you don't have an LPA, the challenge is that you have to pay a fee, to get a deputation. And it's not cheap. I don't mention how much because it depends on which firm you go to. And the irony of the whole thing in that particular case was that the sum of money that they're trying to get out from the deposit may be a bit lesser than what they had to spend to get a deputation. So it becomes catch-22 situation. And therefore, with easy or with the government providing digital platforms as well as the Office of Public Guardian waiving some of these charges and fees, it's really, I can't emphasize more. I've done my LPA and also encourage residents and our union leaders, union members to do it. It's relatively inexpensive. Later, I'll cover some of the legalities or the legal requirements. But please do it because of the number of cases I've seen, the different kind of challenges. You will never face it until someone in your family, not done LPA, gets hit and unable to make legal decisions. That's where the problem comes.
Yeah, like I've fought a few cases also last time when there's no power, lasting power attorney. So family members, they fought over who to become the deputy of the person. So the son will say, I think I should be the one, and the sister say cannot, and then the mother come and say I should be the one. We spend a lot of time fighting who to be the deputy, to look after the father who had lost mental capacity. So this is like the same issue if you were to pass away without a will, who's going to be your administrator? Right. So if you have an LPA, go a long way into avoiding all these issues.
Okay, it's an excellent juncture to then let us discuss the legal requirements for a valid LPA, as well as issues like choosing your donee and this Form 1 and 2, which is, let's talk a bit about that, Mr. Tan.
So very straightforward. There are essentially two types of LPA, Form 1 and Form 2. Form 1 is a prescribed form, generic form. It covers broad, wide-ranging powers that you can give to your donee. And under Form 1, right, you can appoint up to 3 donees. Donee 1, donee 2, and the replacement donee. I did Form 1 myself like 10 years ago. I did Form 1. I appointed my wife as the sole donee. But if for some reason you want to appoint 5 donees because maybe you're difficult to look after or what, then you have to do Form 2. Form 2 is a customizable form. It's a blank form, and only lawyers can help you do. You have to write detail, can give specific instructions, restrictions. Like my donee can take money from my UOB, not DBS. Sell my Bukit Batok flat, cannot sell my, whatever, Choa Chu Kang, this kind of thing. You have to do Form 2, customizable, right? Form 1, most of my clients did Form 1 because it is easier to do. Right, and it gives wide-ranging powers to your donee. Now, what kind of powers? Basically, these 2 categories are personal welfare and property and affairs decisions. So, with a registered LPA, your donee will be empowered to make decisions like, who you live with, where you stay, what you eat, which hospital you go to, what treatment you receive, and also sell or rent out your property, deposit, withdraw monies from your bank account, claim CPF funds, claim insurance money, pay taxes. So, as you can see, they are empowered to do all this. Now, imagine if you don't have an LPA, how is your spouse or children going to do all this for you? Walk into the bank and say, I want my father's money. They can't release the money. So, but if you have an LPA, you can walk into the bank and say that I am a registered donee. This is the medical report of my dad certifying that he lost mental capacity. I am here to withdraw the money. Now, of course, not for himself, to basically look after his father, to always act in the father's best interest. So very broad, wide-ranging powers that you can give to your donors under the LPA, right? So lifestyle, living arrangements, healthcare, property assets, bank accounts, insurance.
And I understand that you can choose to do one and not the other, right? That means, can I say, oh, I want to give my donee powers over my personal welfare? That means he can decide what happens, but then I don't want to give him power over my property and affairs, maybe because I have saved these for like my will, right?
Yes, you can actually, you can customize it, by using Form 2. In fact, within Form 1 itself, there are a few ways you can go about it. For example, you can say donee 1 take charge of personal welfare, and donee 2 take charge of property and affairs separately. Or you can have donee 1 and 2 take charge of both types of decisions, jointly or severally. So a few patterns, you can choose.
Okay.
Like for me, right, I like to keep things simple. For me, too many cooks spoil the soup. So I just appointed my wife. She is put in charge of all both these categories of decisions. So there are a few ways you can,
Somebody did ask me, like separating the personal welfare and property and affairs, but then it occurred to me that if I want my donee to manage my lifestyle, my living arrangements, but then no access to my bank accounts, can be a bit tricky as well, right? Because then does that mean that the donee has to take care of me out of his own assets, his own money?
No, then the donee for personal welfare have to work closely with the donee for property and affairs because require money. And for that reason also, that is why I only have 1 donee. Because if the 2 donees cannot work well together, then it might as well don't do LPA, right? You're creating more problem for yourself and your loved ones. So that is why, just like a will, appoint carefully, appoint your donee carefully, right? Okay.
But if I'm still alive, I'm mentally unwell, but I'm still alive, and I give the donee powers over my property and affairs, including things like you put down here, even insurance policies and all that. So any safeguards? I mean, it feels a bit scary for me because I'm still alive, I'm still here, just mentally incapacitated, and in some cases, hopefully not permanently, right? Meanwhile, the donee has full access to all my property and able to decide everything regarding my healthcare and living arrangements. So legally, are there any safeguards to protect me when I have done this LPA?
Yeah, first and foremost, we have the Office of Public Guardian, what Mr. Tay alluded to earlier. This is the agency that has oversight right over this entire process. So if there is any complaint, right, they are empowered to investigate and prosecute if necessary with the prosecutors. So and of course under the Mental Capacity Act, there are also other safeguards put in place. So there's a general restrictions that says that the moment you regain mental capacity, because you never know, right? You may regain the donie's powers under the LPA will stop immediately. You make your own decision. So the moment the doctor say, "Oh, your dad has regained mental capacity," that's it. Under the law, the powers of the donee will stop ASAP.
I see.
And there are also other specific restrictions. Your donee has no power to sign your will, your CPF, insurance nomination, or change your religion, or change your gender from man to woman, or marry or divorce. So all these are clearly restricted under the law, that your donee has no power to decide to.
Okay, that was useful to know. So from a practical perspective then, earlier, Mr. Tay, you mentioned that, first of all, they have extended the deadline for filing the LPA. And then I'm not sure if it was mentioned right at the beginning at the overview, Mr. Tan, but we were saying now you can do it online. So maybe guide our participants through what is the process like now. If today I say, okay, tonight I want to do an LPA application, how do I start? What should I do?
Yeah. So what Mr. Dick said earlier is that for Singaporeans out there, right, our government has waived registration fee until March next year, right? So Singaporeans out there, you can save money, the registration fee if you register it now. But for PRs, if you have PRs listening in, or foreigners, you can do your LPA too, right? If you have asset in Singapore, if you're working in Singapore, you can do an LPA. It's just that, there is no fee, registration fee waiver for you lah. But you should do. We have done LPA for many PRs and foreign friends of ours working in Singapore. So it doesn't mean LPA can only be done by Singaporeans. PR foreigners also can do. Now, in terms of the process, right? Actually, on 14 November, this entire registration process for the LPA has been digitalized.
Wow.
So right now, all you need to do is to actually use your SingPass and basically apply your LPA and appoint your donee. And when you do that, your donee will receive a notification and they will log into the SingPass to confirm if they accept the appointment. Right? Once that is done, you will also receive a notification that your donee has accepted. And then the last thing you need to do is to contact a certificate issuer.
Yeah, that's
right?
the important one.
Now, that's the important one.
Who is that?
So it's either a lawyer or a approved medical doctor or a registered psychiatrist. Right? So they can then use SingPass also and basically log in and then issue the certificate digitally. So now many things are all done digitally. It's very convenient now.
The only thing is the certificate issuer. So now you have waived the registration and filing fee, but the issuers, the issuers still, it's a small fee to pay to the lawyer, medical practitioner, or the certified psychiatrist.
I see. Okay, so if I've done like the first few steps, right? I've gone online or used my SingPass and then my donee has accepted. Can I just walk into any clinic downstairs my HDB estate?
I think the advice is to go to the Office of Public Guardian's website. They actually have a list of some key points to look out for. I was surfing the website. I did see them illustrating a list of practitioners that you can go to. But however, they did mention in clear terms who are lawyers. Lawyers can be a wide range of. It's a very wide definition. Same like medical practitioners, a very wide definition. So do read there are lists of people who may be qualified to do it for you. So do read the fine print and just navigate the website. It's all available.
Okay.
So you can, or go to Law Society website, to find out, or you can find out the list of approved medical doctors, right? So, or you can Google lah. Nowadays, Google is so easy. Just say, who can be my certificate issuer? You can probably find a whole long list there. Yeah.
Okay, that was useful. Okay, this is an interesting question that's come in, and it's regarding the overlap of the LPA and will. This participant says, if I lose mental capacity and there is an LPA issued before I die, is my will made previously when I was of sound mind still valid? Can my donee override my will intentions? Sounds like this person is saying, I lost mental capacity, I have both LPA and will, but still alive. Yeah.
I think
Can the
important
donee
thing is
override?
to understand the spectrum first. So some can ask me, are they the same document? When do they come into effect? So I need you to imagine this spectrum. In Chinese, called 生老病死, right? LPA comes in before you die. Will comes in after you die. So LPA will lapse the moment you die, or the moment the court revoke or you revoke your LPA. So the moment you pass away, we no longer talk about LPA. That is when your will takes over. But before you pass away, your will has no effect. You can do one tonight, your will have no effect. It only comes into effect the moment you pass away. So this spectrum there, right? So before death is your LPA, your ACT workbook, and all these things. So basically, LPA will come in, your donee will come in with the LPA to look after you, right? Make decisions for you. All the way until you pass away. Now, the question is, if you have done your will before you pass away, of course, you can only do your will before you pass away. You can't do your will in your grave. So if you have done your will before you pass away, and then you basically lose mental capacity, that's the question. You lose mental capacity, it's just like many of us, 70% of us who somehow suffer serious illnesses, right? Doesn't matter, it doesn't change the validity of the will, if that is your question. Because your will was made when you were of sound mind, right? Presumably, all the requirements are satisfied. So subsequently, when you lose mental capacity, it doesn't change your will. It doesn't affect the validity of the will. It will just be there. Until such time you pass away, your will will come into effect. Now, the next question is, can your donee then, change your will, cancel your will, or things as I said earlier, they cannot do that. They have no power. Otherwise, donee will make the will themselves, give everything to themselves. Does that make sense? Correct or not? What kind of document then do we have? LPA allow a donee to simply make a will, cancel your whole will, and make a will and give themselves. Cannot.
That's very assuring. Okay, one more question regarding the LPA. How can the donee know if the donor has lost his or her mental capacity? At what point do I if I'm the donee, at which point do I realize that now is, my responsibility has kicked in?
Doctor's report. So the doctor has to certify that, okay, your mom or your dad, your brother, sister have lost mental capacity and ability to manage his or her own affairs. So you need a medical report.
Oh, okay. So if my parent, let's say early stage dementia, no problem, right? These sorts of things is sort of like a progressive thing. Therefore, my responsibility only kicks in when one day I take him or her to the doctor, maybe just a regular checkup, and doctor says that, oh, the dementia has really reached a stage where, and it has to be a written report.
Yes, it has to be a written report.
Okay. All right.
Or it could be a medical sheet. It has to be written by a doctor who has assessed your mom or your dad.
Okay, very useful. Now let's move on to the Advanced Medical Directive. We will come back if there are any other questions regarding the LPA. Please feel free to still raise them, because when we, at the end of the session, at the Q&A, we can still talk about them. Now, the third and last component of advanced care planning is what is called the Advanced Medical Directive. Mr. Tan, maybe you'd like to just run us through what this is.
Sure. Before I forget, and before you ask also, right, is that your donee can be your executor in your will. So some of you may be special. Can my donee be my executor? Will there be conflict of interest? No, right? In fact, if you can trust your life with a donee, I think you can trust him to be your executor to make sense, right? Just logic, right? Because donee is important, just like the executor. So they can be the same person. Right, and also I think earlier there's a question: can my donee also be my
healthcare spokesperson for the ACP? I was about to ask.
Ideally, it should be the person. Can you imagine you have a healthcare spokesperson who is different from your donee? Imagine they quarrel, that's whole go already. Then what's the point? All right, again, it's common sense. I would say, you appoint the same person ideally if you can, but legally you can appoint different people. But I would advise, why don't you consider appointing the same person? Correct. Otherwise, they quarrel how do myself don't do it. Now, AMD is also a important legal document. Just now we talk about LPA can cover many things, wide-ranging powers, but there is one important matter that your donee cannot do for you, which is life and death. In Singapore, it is illegal to perform euthanasia. Euthanasia cannot actively end your life. But there is this legal document that can allow us to tell our doctors, our healthcare professionals, our loved ones that we do not want to be resuscitated. We do not want life-sustaining treatment to prolong our life where certain factors are met. There are essentially three factors. Unconscious death is imminent and terminally ill. And who decide, right? Basically, it is a very stringent process. You need 3 doctors, right? One is your treating physician, and then another 2 consultants. 3 of them have to certify that these 3 factors are met before they can actually withdraw life-sustaining treatment. So it is an important legal document that can only be done by a doctor. So lawyers like me, like myself, I cannot do it. So only a doctor can do it. And after they do it for you, they would have to register this advanced medical directive with the Registry of Advanced Medical Directive with the Ministry of Health. So there is a registry with the Ministry of Health. So when the time comes, right, they would actually contact AMD registry and find out if you have done the AMD. If the answer is positive and with the 3 doctors confirming the 3 factors are met, that is when they can withdraw life-sustaining treatment.
Okay. Might be a silly question to ask, but looking at it, in the event I become terminally ill, is there sort of like a legal definition of that? Because for the layman like myself, if the doctor tells me I have maybe late stage cancer, doesn't mean I'm terminally ill. And then can I say that, oh, in that case, don't do any treatment on me?
Yeah, that one is for the doctor to assess, evaluate, and determine whether you are considered terminally ill. So medically, they have their own definition whether this patient is considered terminally ill. So it is not for layperson or even a lawyer to say. So it's for the doctor, and whether one person is considered when death is imminent, right? How do we evaluate and decide? Again, it is for the 3 doctors to actually decide whether death is indeed imminent for this particular patient.
I ask because I imagine that if I have made an advanced medical directive, yeah, I think to the layperson it can be a bit scary because we don't know when it kicks in, right? So I may be on the hospital bed and I want to fight for my life, but if it's quite easy, so to speak, for the doctor to say that, oh, this person has reached that stage where I don't need to use any life-sustaining treatment, I'm just trying to address, a personal fear, if I may, if I've made this advanced medical directive. So it's good to know, like you said earlier, that first you need a panel of doctors that's the safeguard, right? To decide that death is imminent and I'm basically unconscious.
Yes.
Yeah. So for those of us who are a little bit hesitant, keep that in mind. Yeah, there are safeguards in place. Okay, so now that we've done the 3, actually earlier we've already dealt with some of this, but let's just move on to differences between the Advanced Medical Directive, the Advanced Care Planning Workbook, and the LPA, right? Those of you who have any questions about any of these, please, ask any question that you may have on Pigeonhole and we'll try to deal with them. I was wondering, the healthcare spokesperson in the Advanced Care Planning Workbook and the LPA DONI will, regardless of whether it's the same person, my question is, will the duties overlap? I mean, is it sort of like the same thing? These 2 things seem to overlap a bit, do they not?
Yes and no, because LPA, right, there is a category of decisions called personal welfare. Personal welfare would probably include your healthcare, treatment, so on and so forth. That's sort of like, if we say overlap with advanced care planning workbook. But LPA generally, right, it doesn't contain all these nitty-gritty healthcare preferences, because LPA is essentially a legal document that actually gives authority to your donee to make decisions. But as to what, the how, it is not contained in LPA. It is contained, all these nitty-gritty, which hospital you want to go to, they're all contained in the workbook. So these 2 documents are linked, they are related, but yet different. So ACP contains your how and what, whereas LPA gives the power to your donee. So basically, donee and spokesperson, although legally they can be different people, but ideally should be the same for the reasons that I said earlier.
So Mr. Tay, earlier you mentioned that you had your will and LPA done. Have you done an ACP?
No, I've not done an ACP as well as an AMD. So I think those 2 are things that I think probably I need to put some priority in. now that we are advocating it. But as you can see, this evening we covered 4 very, very important documents. And it's not so straightforward for everyone because you'll be surprised. I know even professionals that I know haven't even done their will and LPA. So this 4 piecemeal, I mean, in order of priority, will, LPA, ACP, AMD are 4 very, very important documents which I encourage everyone. Basically, why we really speak. I speak particularly more about wills and LPA is because of the incidents and the cases I've seen on the ground with people who are affected by the death of a family member who dies in the state. At the same time, with family members who have now late stage dementia, Parkinson's, or when their mental capacity is put into question for a variety of reasons, sometimes even because of traffic or industrial accidents. So that's where the challenge comes in. And therefore, minimally, now that we have all the resources and all the support, and all the digitalization and very, very strong support nationally, both at the Office of Public Guardian as well as many of our resources across Singapore to help you get your will and LPA done. And those are the 2 most, if Stan may agree, the 2 most important documents to quickly get done ASAP. Now that it's year end, right? It's good time to get it done. Very true.
I agree. Will and LPA.
Okay,
At the
so
very least.
before we move on quite soon, we've got just a couple more slides before our Q&A. For those of us who like to know everything at one go, maybe Mr. Tan, we can quickly talk about some other healthcare decisions outside of already this 4 piecemeal. I think these are less common, but I know they exist. I've heard of the, and I think it might also be on the MSF website or integrated care, right? Yeah, I see. Other healthcare decisions such as Human Organ Transplant Act, the Medical Therapy Education and Research Act. Just very briefly, because I don't think they're so common, but for those of us who are interested, what are these?
Yeah, basically is to consider donating your organs, right? When your time comes. From what I know, I stand corrected, is that it is an opt-in, opt-out thing. So until you opt out, right, you are in. So if let's say that your organs can be harvested, they may harvest your organs when your time comes, unless you opt out.
I see.
So if you want to opt out, you opt out. But of course, later you want organs yourself, you have to wait. Correct. It's only fair, correct. So I think this is how it works currently.
Yeah, but there are some conditions. It's usually in accidents or certain conditions that are met within the HOTA, Human Organ Transplant Act. So that's one important thing. The other one is also recently, a friend of mine, mom passed away. She gave specific instructions for the Medical Therapy Education and Research Act.
Wow. Nice.
So there wasn't a funeral. She before she passed on, she specifically wanted herself to be donated for the medical schools.
I see.
So there's actually no formal funeral. Either Yong Lin School of Medicine or whoever that's being where the body is donated to for education purposes. So they will come and pick up the body and thereafter handle it.
Okay, so that would cover all of our healthcare or rather advanced care planning decisions that we can possibly make. Quickly, let's talk a little bit about getting our affairs in order. Mr. Tay, you already mentioned earlier, right? We all need to have, to get organized, make sure we have an inventory of all our assets, inform a family member where these documents are stored. I suppose even things like if you have a safe deposit box, you should let a family member know or the executor, right? So we will move on from getting organized. Unless some of you have questions, please feel free to raise them. And before Q&A, I'd like to talk about where you can seek help and useful resources. So since this is a collaboration with NTUC, Mr. Tay, can members approach NTUC for help?
Yes, members can come to us. Like I said, there are lots of resources, very useful resources, including Pro Bono SG. I think we have various resources online to help you navigate all these different 4 different spaces: the wills, LPA, ACP, and AMT. Likewise, also as part of this LawWorks partnership between the National Trade Union Congress and the Pro Bono SG, besides running legal primers like this evening session, we also have pocket series. At the same time, also we run a monthly free legal training for union members. So if you are a union member, you can sign up with us, and we have a session by many of our pro bono lawyers, many of whom are serving in and actively practicing lawyers who can give you advice, basic advice on where to go to, what to do next, in case you have queries. But otherwise, if you watch tonight's session, have a watch party or watch this again, you should be able to get nuggets of wisdom and practical handles on how to get these 4 different documents done. And there are lots of resources, but I know some of you who may not have access to digital devices, smart devices, who are not so comfortable navigating virtually. Fret not. That's why we have the legal clinics. That's why we have this help available to assist you and to give you advice and to help you handhold, particularly the elderly. I know many elderly, they may be watching this session, maybe when we push it out on YouTube or other platforms, some days down the road, when we put it on our YouTube, we will hear of this, and you want to do some of these documents, fret not. We have the free legal clinics available across the island, including in NTUC for members, for you to give you quick, practical advice and tips.
Excellent. One useful starting point which I have found, unfortunately for those of us who are more familiar with using the internet, is this thing called My Legacy at MSF. Yeah. So we will be providing a link to that website, and I saw that it does break down each of these tools and tells us where to go for help. So I encourage you to visit the website for a start as well. Definitely, as you have heard right from the start, see your lawyer if you want to get a will done, sometimes even an LPA if it's going to be complex and complicated. Okay, so now I'm very happy to say that we will move into our Q&A session. What this means is we're going to ask, you can ask anything and everything, and we will deal with them as much as we can on the topics that have been raised tonight. Let's start with this one. It's regarding wills, or rather specifically CPF monies. Will shares bought with CPF money be covered by the CPF nomination or the will when a person dies? Mr. Tan?
Will. CPF nomination covers only your CPF balances in your CPF account. Monies that you have taken out from your CPF to buy shares, buy your properties, all this can be covered under your.
Oh, I see.
So nomination only covers what is left in your accounts when you pass away, your balances.
Okay. What happens if the deceased executor also passes on, and there is no second executor named?
Your will is still valid. Your will is still considered valid. The issue is now, who is going to help you administer. So we will need to find an administrator. So usually it can be one of the beneficiaries, or it can be a lawyer even, right? If your beneficiaries are all minor, too young to do, or it can be a relative, but your will is still valid. It doesn't change the validity of it just because your executor has passed away.
Here's an interesting question. I suppose Mr. Tan will have to do with it. Can my will drawn by a lawyer be challenged? And how do I prevent that?
I mean, yes, can be challenged, unfortunately. We cannot stop people from challenging. The question is, can we not? Right? So you must find lawyers who can do a will properly, right? Your will basically must be done properly. But of course, that cannot guarantee, no contest. But at least it can really protect the integrity of the will and to protect the wishes of the client. So basically, to answer your question, yes, it doesn't mean that you will not be contested or you cannot be contested. The question is how successful can contest people.
Okay, this is an interesting question. This participant says, my parents are into their 90s. They are receptive in making a will, but how can I arrange for this without being misunderstood by my siblings as influencing their decision? So I wonder if you might have encountered this kind of questions, Mr. Tay, when you meet the residents.
Definitely. I think there's always this challenge. So I mean, this goes into practical handles. So how do we? So it's important, particularly if you're handling seniors. I mean, it's good to have a family conference. You bring the family members together so that people don't second guess each other. I think the key thing is you want to be clear, transparent, and open, and communicate it very clearly. I think that's important because at the end of the day, we also want things to end up peaceably and happily. It should not become a moment of acrimony or issues later on, especially if it's siblings who are sometimes not on talking terms. So very, very important to do it in an open and transparent manner. So that's my advice. Having seen some of these cases that happen, because I have cases where on one hand, one of the siblings come to me, and then like what Tan mentioned earlier, another sibling comes, and then the wife comes, and then it's quite it becomes quite bitter and very, very acrimonious. So I think so the best advice is if you need to do some of these things, have a family conference, do it together. I think lawyers too will provide quite personalized services to my knowledge, because I actually recently got help from one of the lawyers who to visit a particular senior, because she's in her 90s. So needed a lawyer to go there because she's really immobile. So there are lawyers that they can arrange to come to the house, in a family conference or together with family members, so that we can do it in a very open and transparent manner.
There are two questions here that I think essentially ask the same thing. Can I appoint a company or organization to be an executor, or must it be an individual?
If you are talking about licensed trust company, yes, you can appoint a licensed trust company. So who are these? These are companies regulated by the MAS. You can actually go on to MAS website and check out, this licensed trust companies. They will provide these kind of services. But other companies, the answer is not, in my experience. Most of the time, in fact, all cases, they are either licensed trust company or individual. Right? Individuals.
Okay. Now, someone here has asked about digital assets we mentioned earlier, right? So they want to know, what are digital assets? Can you give some examples? Are they considered movable or immovable property? And I'll just go on and ask the other question regarding digital assets transferring from the deceased to the beneficiary. How do I transfer digital assets under, say, a will?
Yeah. So all these digital assets I referred to are the movable property ones. For example, you have a digital wallet holding. Nowadays there are so many fintech innovations. You can keep cash, you can stash cash, you can stash foreign currency, and many of the digital banks that are available these days, and digital wallets, and even the digital cards as well. So sometimes you are able to store cash in those platforms. So important, therefore, I mentioned earlier about the list of assets inventory list to highlight. It's not easy because particularly if you travel a lot and spend a lot through these various platforms, it's a moving kind of like balance. But more importantly is to highlight the numbers, the codes, and all the details, so that in the event that you need to access the executor or whoever is administrating needs to access this, they know where to go to, which fintech platform they need to go to pull out these monies. Because mind you, sometimes it can be quite in the large amounts. Particularly now with crypto, I know many people are into crypto, of course, minus a scare. They are actually crypto wallets as well. So you might have digital assets, for example, like Bitcoin, Ethereum, or other tokens. So these and increasingly now with metaverse, you have NFTs as well. So all these these platforms, they are usually hosted by a particular wallet or company. So good to outline these in a very clear manner, so that in the event the executor needs to access it or to work with the lawyers to access it, whatever the amounts may be, you are able to access it.
And also to add on, in estate planning parlance, right, there is a document called the Memorandum of Digital Asset. So it is like a compendium where in this memorandum you list down, like what Mr. Tay said earlier, all the platform, all your accounts and details and all this. And then in your will, there will be a few clauses added to direct your executor to basically execute and administer your digital assets in accordance with the instructions of the memorandum. So behind the will, if you have digital assets, there will be this memorandum attached to the will.
Wow. Okay. Okay, I'm just going to ask one last question before we have to close tonight. If I'm mentally sound but bedridden, do I need an LPA or would a power of attorney suffice?
Okay, power attorney essentially is an administrative document. Like for instance, if you need to travel overseas, you can give a power attorney to somebody to help you administer certain things. So it is an administrative, whereas lasting power attorney is a different legal document. It comes into play, comes into effect when you basically lose mental capacity. So both are very different. I would say LPA is like a subset of power attorney, but they're essentially very different documents.
So I would imagine that the straightforward answer is if you are mentally sound, then no, right?
Yeah,
the LPA will not kick in.
Yeah,
right?
LPA will not kick in.
But the power attorney in such a case may be useful because as shared in that question, the audience says it's bedridden. So sometimes some legwork needs to be done. For example, when dealing with assets, and you need to see the lawyer, you need to go to the banks and stuff like that. So therefore, a power attorney is useful if you can't do those things when you're bedridden.
Yeah.
And you need to be physically at a particular location. Therefore, the power attorney would be useful. So both documents are recommended, particularly if you are dealing with extensive liver assets and different kind of assets.
Okay. Well, with that, I believe we have come to a close for today's session. To our participants, we hope you found our discussion useful. If you're facing any issues, if you still have questions, and if you're an NTUC member and keen to register for a legal clinic session, you may write to LawWorks at ntuc.org.sg. If you are a non-NTUC member, do consider registering with them or approach Pro Bono SG at help@probono.sg. With that, it leaves me to thank our speakers, Mr. Tan and Mr. Tay, for joining us today and for their invaluable insights. Thank you both so very much.
Thanks.
And for the rest of you, a survey will pop up on your screen for your completion. We appreciate your comments and feedback. We will use them to improve our future webinars. And on behalf of Pro Bono SG and NTUC, we would like to thank all of you for joining us this evening and have a great week ahead.
Thank you.